All right, everybody, good morning. Thank you for another Friday morning coffee. I really appreciate everybody being here. It's kind of interesting. This is a topic that we've actually talked about a few times, and we try to pick things that maybe people aren't talking about as often as they should, and so that we can get out in front of some of the things that are coming. Well, I'm sorry. For those of you who don't know me, I'm Rob Johnson. I'm over organizational development for HTI. If you don't know HTI, we are primarily an HR consulting and staffing firm that's been here in the upstate since 1999. We are currently 11 offices in 7 states. So something along those lines. We a bunch of offices in a bunch of places. But this was the brainchild of young lady Jen Lackey that we had been doing some training in-house for a long time. So every Friday morning we all get together, we talk about a topic. And the more we began to talk about it, the more we went, there are people who are interested in different things in the HR community or in other communities, so can we not share those? And we began to reach out to people in the community that we knew that were experts in certain fields and say, can you come in and share with us about a topic? So all of these, we record all of these, so this will be edited and actually put on YouTube. We have a YouTube channel, so if you have an interest, we can make sure you get the link. We also have a series of other things. In fact, the last one we did was on the Fair Labor Standards Act, and that was probably one of the best attended we've had because I think everybody's going, what is about to happen? We don't know what to do. One of the reasons we wanted to do this topic was currently there are 26 states that have some level of either legalization or decriminalization of marijuana. And the recurring theme that I found in everything that I've read is that most voters, when they actually voted for the referendum, they didn't actually think about what it meant to the workforce. They just basically said, yeah, we think we should have this option. And so employers are kind of stepping back and figuring out how that impacts us and how that impacts us operationally, on policy and procedures, what we can and can't do with those associates. And I think like anything else, in my conversations with Steve, he keeps going, the world's not coming to an end. It'll be okay. But I think that's the way most of us are looking at it. The marijuana's coming and we're going to be overrun. But, so let me give, because Steve has quite the impressive resume, so let me give you a little bit of background. So this is Steve Buckingham. Thank you for being here, Steve. He's an attorney here in Greenville, and as of January 1st, he is an entrepreneur. He is self-employed, so he runs his own firm here downtown. His practice focuses on representing small businesses and essentially whatever challenges they're facing. He's there to help solve them. So he is a 2003 Phi Beta Kappa graduate from Furman, a 2006 graduate of the University of Richmond School of Law, where he served as the editor-in-chief of the Law Review. His first job out of school was a law clerk to the Chief United States District Court Judge for East District of Virginia. Came back to Greenville in 2007 and started out as an attorney with Nelson, Mullins, Riley, and Scarborough, practicing civil litigation and employment law. Steve is a member of the board of directors for the Greenville Chamber of Commerce, a Reach graduate of Leadership South Carolina, recipient of South Carolina Leadership and Law Award, and has been recognized 4 years running in Super Lawyers. You have Super Lawyers?
Super Lawyers.
That's awesome.
My cape is under my coat.
And he is among Greenville Business Magazine's legal elite. So, first and foremost, thank you for getting up early and coming in and talking with us. I know, my first question out of the gate is, we don't have any sort of decriminalized or legalized medical marijuana in South Carolina. Why should we be talking about this?
Sure. Well, first of all, can everyone hear me without the mic? And I don't know if I need to use the mic for purposes of recording.
It helps with the recording.
We'll do that then. I don't want to yell into it, though.
No,
there we go. All right, there we go. I thought your first question was going to be, given the topic this morning, am I the upstate 420 attorney? I am not. So when you hear those commercials, that is not me. Don't be confused. Thank you all so much for having me. I really appreciate the opportunity to talk with you, everyone. Like you said, I think the reason to be talking about this is just to make sure that we are not caught off guard by anything that might happen in the future. Obviously, South Carolina does not have any type of medical use legislation that's been passed or certainly legalized marijuana or decriminalized. But I think there's a fair amount of confusion nationally just because of the differences among the states of how things are being treated. Some states, as we know, have decriminalized marijuana. A step up from that, they've permitted a medical use type of situation for folks. On top of that, as an escalation, you've got states that have permitted recreational use. And so the question, thank you. The question is, well, what do we do in these changing landscapes, and especially if you work for employers that aren't necessarily located in South Carolina? What if you've got a location in, say, Colorado, or you've got another one in Michigan, or you've got another one in Connecticut, and each of these states has a different regulatory environment for how they treat marijuana? You can look at that and think, oh my God, how in the world do I, as an HR professional, possibly deal with that? And that does cause a fair amount of chaos. It looks like a chaotic structure from the outside. But the reality is, and we'll talk about this more today, from all that chaos, we can make order from it. And very simply, and we can talk about examples of how there is still order in this chaos. The order, surprisingly enough, comes from the feds. Marijuana continues to be, has been, a Schedule I controlled substance for a number of years. And there's no sign that that is going to change. And so as long as marijuana is on the controlled substance list, there is no exception within state law for individuals to use marijuana on the workplace and to be terminated or disciplined or otherwise because of that federal legal structure. So there's no right federally to use marijuana. And if there's no right federally, well, we fall back into that same Lockheed Martin type of factor that we see when we're in wrongful termination litigation or discrimination litigation. You, as an employee that claims that you have been the victim of some sort of wrongful adverse action by your employer, you've got to say, I had a right, I'm part of a protected class that got violated, those rights were violated, where I was discriminated against. And what's your basis there? My protected class is I'm among marijuana users? I mean, there are folks that have been alleging that, and guess how far that's gotten? Not far at all. Those cases have been kicked out of courts, even in states where there is recreational use. You've got this tension going on between state law and federal law in a few jurisdictions, and when you have tension like that, spoiler alert, the federal law always wins. So that was kind of a long-winded answer to your question, but the reality is, why we're talking about this is because at some point, and who knows when, we can have a debate about when South Carolina might look at having some sort of accepted use for marijuana. How should employers in South Carolina respond to that, if at all? And I think a bigger question would be, and maybe a question that arises before South Carolina looks at an accepted use, what happens if the feds have an accepted use? And I think we'll talk about some examples and some hypotheticals with that this morning. The last thing I want to do is bore you guys by lecturing to you. I really hate that. You know, you're already spending your Friday morning listening to a lawyer, and I know that's probably not an exciting thing. So what I would really like to have is just a conversation where we talk about hypotheticals. You know, we try to bounce around ideas of what a landscape looks like, and we process it all together, because the fact of the matter is no one knows what the environment will look like in the event that the feds decriminalize marijuana or take it off the schedule or provide a medical use statute. No one knows what that looks like yet. And so I think by having a conversation together and brainstorming and tossing out worst case scenarios and how we would respond to it, I think everyone can learn from each other, and certainly I can learn from you guys. So that's what I'd like to achieve this morning.
Steve, let me ask you, so you mentioned this several times, and you're going to handle that. You've mentioned them just simply taking it off the Schedule I. Mm-hmm. What do you see as being the overriding impact of, let's just say they simply do that. Maybe there's not a full decriminalization, but they go, you know what, we don't consider this a Schedule I anymore. I mean, what are some of the things that could potentially come out of that sort of move?
So I think if the feds were to take it off the schedule, and I guess part of the assumption of that question, let me set my coffee down. Part of the assumption of that question is South Carolina would continue to regard marijuana possession use as a criminal act. In that type of environment, I still don't think that much changes for South Carolina employers, right? If the feds say, all right, we don't have a position on this anymore, either we're not going to enforce the laws regarding criminality of marijuana, or we will even legalize its use. Let's take medical use off the table for a second. I think that's a much more complicated question. But if they were just to take it off the schedule, and South Carolina were to still say, you know what, as a matter of state law, this is prohibited, then I don't think that anything changes day to day for employers. Under state law, you can still have your testing that goes on, both for hiring, and you can also have it for folks that are already employees. Because again, there's still no right there to use it. There's no permission from the state to use it, and I don't think that you would experience any significant or any liability from terminating someone that showed up hot when they took a drug test if state law still says this is criminal. So I don't think that changes. Now, we can get into the deep end of the pool if you want to and talk about what happens if the feds were to create a medical use type of permissive situation. I think in that event, I think the regulatory landscape changes pretty dramatically. Right now, as I'm sure a lot of you guys know, everyone knows, under the ADA, if you use illegal drugs and you try to claim that as your disability, that doesn't take you very far, right? That takes you nowhere. There is no protection under the ADA for folks that use illegal drugs. As long as marijuana is illegal, there's no ADA compliance necessary or ADA issues. It's just summarily, you're gone. But if marijuana becomes something that is permitted and taken off the schedule of controlled substances and is no longer federally regarded as an illegal substance, now there may be some ADA compliance issues. Again, no one knows what that looks like because no one's had to face that yet. Any college football fans in here? Anyone? I am. I'm a huge one. So I don't know if you remember this. This was just last season. The coach at USC, not South Carolina, but Southern Cal, was a guy named Steve Sarkisian. And USC is a much storied, much ballyhooed program of football, and Sarkisian could not get a win to save his life. He could not motivate his team to get a win. And in fact, mid-season, they were playing a team that they should have absolutely destroyed on the field. And at halftime, the athletic director comes down the field and fires Sarkisian on the spot. Well, it turns out that Sarkisian was drunk at the time that he was fired. So he's on his job, he's drunk, and he gets fired. There was a wrongful termination lawsuit that came out of that because Sarkisian's position was, well, I'm an alcoholic, and this is a disability, and you guys did not make a reasonable accommodation to me. You just fired me outright. So I'm not aware if that litigation is still going on or not, if they've settled or what the status is. But I think that's an important parallel to what could happen in the marijuana landscape, right? You could have an employee that comes in, and so, you know, federally, marijuana has been legalized, or maybe there's even been a medical use application permitted. Maybe he comes in and he's high on the job. She's high on the job. And your first instinct is, I want to fire you. Well, it could be that under the ADA, you've got to make a reasonable accommodation to that individual? I think it depends on the nature of their use on the job, right? Is it because they're addicted? And if they're addicted, do you have to try to provide some sort of treatment to them before you terminate them or otherwise discipline them? Maybe they're using marijuana in order to treat some other condition that they have. Maybe they've got terminal cancer, and the only way they can manage their pain anymore is by using marijuana. And it's so advanced that they have to use marijuana before the job, on the job, after the job. And so I think in that landscape, you could have an issue where you have to make some sort of accommodation, or at least explore whether there's accommodation in order to avoid liability. And it seems crazy to us right now talking about this, right? I mean, here we are talking about the possibility of an employee needing to smoke up on the job. Now, if we were at Mellow Mushroom, this might be a different story, right? I think that's a job requirement. I probably just got sued for defamation since this is recorded. Edit that part out. Thank you. But how crazy is that you know, we could talk about circumstances, probably from stuff that you guys have just seen in your own business environments, of where employees could come up with, you know, some justification for why they needed to smoke on the job. I mean, let's face it. We've all seen instances where employees are really creative in trying to grift the system, right? Not everyone. There's plenty of great employees out there. It follows the 80-20 rule, right? 80% are great, 20%, not so much. And the ones that aren't so much are really creative at coming up with ways to manipulate the rules and do whatever, and especially in the age of the internet, you know, when you can sit down and Google and see what other chat rooms are saying about, you know, I did this with my employer and I got to, you know, use alcohol on the job or smoke on the job or whatever. It could be a really complicated thing. It'd be like wrestling with a mushroom, a marshmallow, to accommodate each of these challenges that a creative employee might come up with to justify why they want to smoke on the job. So that's a long time off. I don't want to be doom and gloom, because I don't think that doom and gloom really exists in this type of landscape. You know, the Romans had this saying of nothing is new under the sun, and that was from 2,000 years ago. If they said nothing is new under the sun, then certainly for us nothing is new under the sun. And we can find corollaries to what would be going on in terms of prescription drug use. You know, I think that would be a great place. Alcoholism, I think that would be a great place to look at drawing some ideas for how we would respond to marijuana in the workplace. So we can find authority to help guide us through this landscape. But I think the stories that will come off the initial wave will be some really great stories. That's kind of why I love employment law. Employment law and criminal law, you get the best stories out of them. The things that employees do on the job can be absolutely crazy, and things that you would love to tell over cocktail parties. And I think that when marijuana becomes, something that employers can't necessarily take a zero tolerance stance on, I think some of the stories coming out of that are going to be really fascinating. I'm looking forward to that piece of it. Responding to it, maybe not so much, but once the storm has passed, I think that'll be something that we can look back on and say, man, that was nuts.
Well, I'll gladly sit here all morning and ask questions. Are there any specific questions that the group wants to make sure that we address today, or scenario, or, because I have my list, but I want to make sure that we're answering the things that, yes?
I'm listening to you talk, and thank you for coming, Steve, and talking with us, because I'm not only a recovering addict, I work in the recovery community, and I give back in a way. And when I heard this conversation was going to be today, I was like, I got to be there, because it's important for this conversation to take place not only here, but in the homes and in the government. But one of my questions is, and I just happen to be privy to a family member that lives in Oregon, Washington state line. They have a medical marijuana. They have a marijuana dispensary, and in my distaste in drug use period, I've come to a fact to know that medical marijuana is important, and the different ways that it's processed have a different effect, and they are effective a lot of a broad spectrum of diseases that can affect us. But I think my question is, do we know that there are studies that are being done to model what we have, what is coming our way, with what the states that do have that law that is in effect? And I mean, there's things that we can to be learned from what they're experiencing in those areas.
Yeah. So yeah, there are studies being done to see from a bunch of different angles to see what the impact is of having a medical use allowed as also recreational use. And it's not just from the perspective of what are appropriate content levels for various types of delivery systems for marijuana, whether you smoke it, whether you eat it, whether you drink it, whether you ingest it by pill. Those studies are going on, but it's also looking at what is the economic impact in terms of tax revenue. A further step from that is, okay, you've got tax revenue that's generated, less potential increases in law enforcement costs, and frankly, like child protective services. There's a lot of cases coming out of kids in homes that are ingesting brownies, and I know there's a big debate about whether or not you can overdose on marijuana, but that's the shorthand to say it. That kids are being taken to the hospital more with having ingested marijuana at home, even though the parents bought it lawfully. What the social impact is of that. So there's a lot of different angles that the states are looking at, and I think that's going to guide how other states respond in their own policies to this. And I think the feds are looking at that too. You know, everyone always talks about how the states are kind of like labs for the larger government to see what works in terms of policy and what doesn't, so the feds can adopt it. And I haven't really believed that's true for a long time. I think the feds kind of control a lot of things without giving really any ability to the states to be a laboratory. But I think this is one area where the states really are being laboratories to see what does this look like as we ease our way into some sort of accepted use of marijuana. So yeah, so those studies are going on, and you bring up an important point about your own background. You say that you're a recovering addict, and I think that's tremendous. Congratulations. So let's consider the scenario where we wave our magic wand, and tomorrow, South Carolina and the feds allow marijuana use. It's recreational use even. So it's not illegal under state law. It's not illegal under federal law. You, as an employer, as a representative of your employer, you're thinking to yourself, man, I know it's legal, but I don't know how comfortable I'm going to be with having employees that use marijuana regularly. I think that poses an interesting question about the types of background searches that you can do at this point. Maybe you want to do a background search to see if they've ever been convicted or charged with a crime for possession of marijuana, because you might want to use that as an indication that if they've been charged with it in the past, that they're more likely to use it for you, or not for you, but when they become an employer of your organization. And that might induce you to not hire them. I think that would be a minefield, frankly, because you don't really know why someone was using marijuana. You don't know why they were in possession of it. It may be because they just love it. It may be because they have terminal cancer and they were using it to treat themselves. And so back when marijuana was illegal under our hypothetical, they got picked up even though it was a medical use. They got charged with a crime, but they were doing it to treat themselves. But now that it's not illegal anymore, it is legal, you'd be using that information which you weren't aware it was for a disability, but you'd be refusing to hire someone on the basis of that conviction, even though it arose from them treating themselves for a medical condition. That's frightening, all right? Now we're talking about, essentially, at least as a lawyer, I can make the argument, well, they discriminated against my client because of their disability. Your response would be, I didn't know you had a disability. Well, too bad. Tell it to the jury, all right? Yeah, go ahead.
I should make a comment. You were asking if there's any studies being done. There's a fantastic guy named Kevin Wong down in Colorado. He works with Rocky Mountain HTI, that's High Intensity Drug Trafficking Area. So they are doing a lot looking at the societal impact, so looking at tax revenue, law enforcement, overdoses, hospitalization. So I think it's a long report. I think it's a really comprehensive look at Colorado and the impact of both medical and recreational. So I was just looking at the other day. Kevin's fantastic. So he's someone who's really easy for contact with a specific question.
Oh, wow, okay.
Melissa, do you have something?
Yeah, we have a question from online. So if someone goes to Colorado on vacation and consumes legally, and then comes back to South Carolina and fails the drug test due to half-life of marijuana in your system, they're not actually under the influence on the job, if they consumed it legally in the state of Colorado. So is there any litigation around that issue?
Well, you can sue any. But if you come back to South Carolina and your South Carolina employer has a zero tolerance policy and they get tested and they come back hot and they get fired, there is no basis for wrongful termination there. We've not really seen that yet in South Carolina. In other states, you have seen some sporadic cases like that, and that's the way it's coming down.
Steve, I know one of the hottest, Colorado very clearly is sort of the hotbed of everything right now. But under the Coates case, within Colorado, that was actually one of the first ones to really take off. That was even before personal usage. It was just medical usage.
That's right.
Can you talk a little bit about that case and sort of how it evolved and where it stands?
Absolutely. So I'll do that, and we'll get to your question back. All right. So I don't know if folks are familiar with the Coates case that came out of Colorado. Just looking here. Okay. You probably cannot imagine a better first test case for an employer's rights of termination of employees for medical for marijuana use in a state where marijuana is legal. Okay, I mean it doesn't get any better or worse depending on your perspective than this.
More complicated.
More complicated. That's right. So here's the fact pattern behind it. The plaintiff, a guy named Coates, he worked for Dish Network. Coates had been a quadriplegic since he was about 16 years old. He was in his mid-30s, I think, when the litigation was going on. So, no use of his arms, no use of his legs. And he gets a job at Dish Network in customer service. And he is amazing at his job. I mean, Dish Network is a huge company, and he was routinely in the top 5% of people who are in that role and who are recognized by their superiors as doing an outstanding job. I mean, he was the model employee. He's a quadriplegic, and he's in a lot of pain. And so for a number of years, he'd been taking opioids to treat his pain, and he got desensitized to it. He grew a tolerance for it. And then once marijuana for medical use was accepted in Colorado, his physician said, we're going to put you on medical marijuana, and hopefully this will take the place of your opioid use. So Coates starts smoking. He only smokes on the weekends, and he smokes a couple of times during the week in the evenings. He never smokes on the job, anything like that. Yeah.
What was interesting about this also, he didn't have to do this, but he actually went to HR and said, I have this medical condition. I have been prescribed. Here is my prescription. and turned over his medical information to HR. And HR did what they were supposed to do, which is nothing. They filed it away and
Yeah.
sent him back to work.
Well, and even then, he comes into work one day and HR says, okay, we're going to randomly test people, and coach gets pulled out to be randomly tested. And he tells the folks who are testing him, hey, I have a prescription for medical marijuana. I need it for my condition. I'm going to turn up positive for marijuana use, just so you know. And they say, okay. And they test him. Sure enough, he shows up hot for marijuana. This is Colorado, right? The homeland of accepted medical uses for marijuana, personal uses for marijuana now. His employer, Dish Network, had a zero tolerance policy. They fire him, okay? He sues, wrongful termination. I need marijuana to live. That's his argument. It's a pretty good one. If I'm a plaintiff's lawyer and I get this guy and I can sue Dish Network, this is the guy that I want. Model employee needs marijuana to live, pain-free at least. He's not abusing it. Well, didn't make it to the jury. As a matter of law, the court found, look, first of all, marijuana continues to be a Schedule I narcotic under federal law. So you have no protection under the ADA. That's out. And in terms of wrongful termination, even though there is a statute in Colorado that allows for medical use, that doesn't give you the right, employee, to use marijuana and to be free from any type of adverse action from your employer. All that does is allows you to say, if you are arrested for marijuana possession and use, you can say, oh, as a matter of criminal law, I have a defense to that. I've got this prescription. But as a matter of civil law, employment law, your employer can still fire you if they have a zero tolerance policy. And even though you've got this prescription, and even though you took the marijuana in furtherance of that prescription, sorry, that's the policy, you lose. So that was the trial court's decision. Of course, that was appealed up to the Court of Appeals, which affirmed the decision of the trial court. That was appealed up to the Colorado Supreme Court, which was affirmed. So, as a consequence, that is the core case right now in America about an employer's rights, even when there's a state law that says you can use this medicinally, you can use it recreationally now, but that still gives employers the right to terminate for zero tolerance. It doesn't get much clearer than that. You know, if he was abusing it, that'd be one thing. If he was smoking up on the job, that'd be one thing. But here was a guy that was following the prescription, who needed it medically. There was no question about that, no dispute on those facts. And still, the law is employers you can terminate. So that's why I say all is well, everything's cool. Even if South Carolina were to legalize tomorrow, as long as the feds hold tight to it being a scheduled narcotic, nothing really is going to change in terms of the legal landscape. Yeah.
I think you just answered it.
Okay.
My question was, does company policy override, I guess my example was, when I first thought I was coming over here to listen to the marijuana thing, I was thinking, well, alcohol, there's a difference in marijuana and alcohol, except for marijuana's in your system 30 more days, right?
Yeah.
So if you take a drug test and it's in your system, even though it was 3 weeks ago, does the company still have the right to fire you, or versus what would be upheld? And then I was thinking, if there was a medical use for it, I would assume you would have to have a form similar to like an FMLA form that says, hey, this person should basically just cover that.
Yeah, so, okay, let's talk about that, though, in terms of the forms. How are we doing on time? We good on time?
We're fantastic.
Oh, perfect. Okay, good. Let's say that someone comes to you with a prescription for medical marijuana, and you want to file that away in the personnel files. I think you've got to be very careful about that. And this is still an uncertain landscape too, frankly. I mean, for better or worse, we're all familiar with HIPAA and the privacy rule that goes with it and the security rule that goes with it. I don't know, and if anyone wants to chime in about what their internal policy is for putting health information with an employee's file, or if they file it separately, I'd be curious to know what your answer is. I think the same type of debate is going to have to go on with medical marijuana prescriptions. You know, if I think that could be construed as protected health information, because the medical marijuana prescription could be regarded as potentially evidence of an addiction. It could be regarded as treatment for another primary condition that points, the medical marijuana prescription points back to the existence of some other disability that you'd have an obligation to keep confidential. I think record keeping gets a little cumbersome, maybe not more than it already is, but I think it's something that HR professionals will have to pay attention to in the event that someone comes to them with a medical marijuana prescription.
You're also seeing that in every single state that has some sort of either decriminalization or legalization, all of the lawsuits that have come out so far, especially those having to do specifically with medical, invariably the courts have warned employers, do not allow your ability to terminate this associate dive deeper than just the usage itself. Because the moment you reach that and begin to look at the underlying need for it, that's where you're tripping over ADA, FMLA, workers' comp. There's a wide variety of things that you can get yourself into trouble with by even just digging too far into why they're using it. So, in the research and talking with Steve, it is, so far, every single state that has it, the courts are still ruling very much the same way Coach does. We also see, for example, so HTI, we have a warehouse division. And you look at any manufacturing facility, forklift drivers. The Drug-Free Workplace Act. So if you get any sort of federal funding, you have a zero tolerance responsibility or you face fines. But also there is a caveat that basically says if you have safety sensitive positions in your facility, which could be a forklift driver, it could be anything where they could hurt themselves or others, you can absolutely go, even if we have personal use. As an organization, you can go, yes, I know it's legal, but the type of roles we have are safety sensitive. Also, there's very specific rules regarding CL drivers. There's a lot of legislation that even if, like you said, if it was not a Group 1 controlled substance tomorrow, there's still a lot of other laws in place that are going to go, that doesn't mean everybody can start smoking that tomorrow. So, well, we're also going to have a lot of our employees who decide that that's exactly what they're doing.
Well, that's just it, right? So there's a strong misconception out there, especially if you just go and Google this. I did this just last night for fun. I Googled termination marijuana just to see what was out there. And sure enough, there are pages and pages on Google of folks that have posted questions, maybe on like Yahoo or some other public forum, where it's just like, can my employer fire me if I smoke marijuana? I'm in Colorado, something like that, or I'm in Washington, I'm in Oregon. Yeah, and people think, and you'll see like responses from folks who are less than expert in the field that are saying, no way, we got a right to do it now. No, you don't. There is no right to do that. And one thing I'm failed to mention is that the Colorado case, even as strong, that Coach case, even though as strong as that authority is, it's even stronger than I represented to you, because I left out this part of it. There's a statute in Colorado that says that an employer cannot take adverse action against an employee for things that they do that are lawful on their own time. Part of his argument was, hey, I'm smoking up weed on my own time and it's lawful. The response was, no, it's not lawful. It's a Schedule I drug. Under federal law, it's not lawful. So it doesn't get any stronger than the Colorado case. And if that, if not even that, in those facts, is enough to overcome the zero tolerance policy in the workplace, then it is going to be a long time and a very unusual set of facts before we see some case involving marijuana finding liability against the employer for wrongful termination. It would take a very unusual set of facts, an extreme one, even more extreme than the one I gave you, to get there, or a change in law. And I think it would require the change in law, frankly. Yeah.
If the legislation comes down and marijuana is legal, what are we thinking about employers who are not a fan of the legislation and they have targeted random drug screens that target people who they think are smoking, and those people will file discrimination?
Well, to tack on to what Rob was saying, one of the legislative responses we're seeing in states that have authorized some form of use is that you can designate certain positions as security sensitive or safety sensitive, something like that, to where even if marijuana use is permitted generally in the state, if you occupy one of those sensitive positions, you as an employer can still say that there's a zero tolerance policy. So that, I would expect something like that certainly to happen in South Carolina, and probably even to happen at the federal level in the event there's a change in law. As far as the other drug screens go, I really don't think that that it will change in any meaningful way. Well, let me qualify this. If the feds were to come and just decriminalize marijuana or even legalize recreational use, I don't think under those two circumstances that changes anything about the employer and how they do business and how you can do drug testing. I think the big change comes if the feds were to create a medical use circumstance, because then I think that you, as an employer, can get into a lot of difficulty with pre-screen drug testing. And I'm sure that, if we sat around for probably half a morning, we could probably figure out exactly what type of policy to put in place to protect you guys. But, it could be that that if you get employees that come back and they test hot for marijuana, from the example that we gave before, it may be that you say, all right, we're not going to hire you because you tested hot and they've got a medical condition. Now what are we going to do? Are we going to require employees to disclose that they have a medical marijuana prescription as a condition of employment? Maybe, but that seems like it would get really close to requiring them to talk about the underlying circumstances for the prescription, and that becomes a dangerous thing to do. And certainly for employees that you randomly test, I think you run into the same types of issues. You can maybe have a disciplinary procedure in place that you've got to provide a doctor's note for a medical marijuana prescription that you can keep on file, so that way if they come back incident to a random drug test and they test hot for marijuana, at least you know why. That might be something permissible you can do. But I think if medical use marijuana were become authorized at the federal level, I think it becomes a dangerous game to start playing when that would be the basis of a termination, just outright, pursuant to a zero tolerance policy.
Well, for example, if anybody who works in manufacturing, like our current policy, if we test someone, let's say we do a pre-employment drug screen, and they come back and say they have not passed the pre-employment drug screen, we have the option to send that person out for an MRO, which basically they meet with a doctor and they're my conditions, all my prescriptions, And essentially what we get back from the doctors to know going, based upon essentially current legislation, their medical condition, and the medication they're taking, they did or did not fail this drug screen. And that's really all we know. And I would assume at that point it would fall into the same category, that marijuana would be that piece that we sort of know, but we don't know. And if they turn up the paperwork, if the doctor says, no, they didn't fail this drug screen, we have to go with what the legislation says, what the doctor says. I think where things are going to get more complicated, and as I look at manufacturing, I was meeting with our safety manager recently, and OSHA has recently come back saying that most organizations, if you have a safety incident, you have a mandatory drug screen. And OSHA has now said, well, did the likelihood that the person was impaired directly impact the incident itself? So if I am walking down an aisle and I slip on a puddle and fall, and you test me for marijuana and I fail, does that mean that you can terminate me? In the eyes of OSHA, not necessarily, because did it impact, did my being high impact me slipping on the puddle on the floor? But if I backed a forklift into a rack or something like that. So there's, I think you have a couple of different areas of drug testing that are all going to come to a head at some point, should that legalization pass. And I think there's going to be a lot of settling exactly what the case law is going to be. And to the point you made earlier, all the cases that are going to initially come out of this are probably going to be awesome and amazing. And it's just figuring out what the law states at the other side of all these crazy conversations we have to have.
Yeah, and I think that's a good point. I think there's a general trend in the law, frankly, not just in this area or in employment law generally. I think there's a general trend in the law to treat every case as if it is fact-specific. And that's different because once upon a time, and certainly 100 years ago, you would have these cases come out over a very precise issue, and the courts that would rule on it would give these sweeping propositions of law that kind of set the framework for that area of law coming out of that one little case. And over time, over the past 20 years or so, judicially, nationally, there's been a retreat from that back into, okay, everything is going to be fact-specific, everything is going to be case-by-case, and we're not going to do these sweeping propositions of law anymore. And I think that's how, that incremental way is how these cases are going to be decided in the event that this time comes. And so, knowing that, I think that one thing that would be wise and prudent for HR professionals to do is, okay, for your harder drugs, yeah, okay, that will be zero tolerance. We can continue zero tolerance there. But for marijuana, it may be that we've got to back off of zero tolerance. It may be that we've got to take maybe a progressive disciplinary approach to it. You test once and you're hot. That's a demerit against you. You do it twice in a certain time period. Maybe that's basis for termination. Certainly you show up high to the job. I don't think there's going to be any legislation anywhere. I shouldn't say that. I would be surprised if there's not going to be legislation that would carve out protection for employers to terminate when someone is high on the job. I think there are scenarios where maybe under an ADA reasonable accommodation thing, that would be possible. It's unlikely, but it's possible. But in terms of a general proposition, I think that employers will be protected from having employees on the job who are under the influence of marijuana. You could have, I think this would be difficult, especially at this stage, you could even have like a tolerance threshold. I don't even know how they, that marijuana would be measured inside the bloodstream or whatever, what the proper measurement is. But you could, just like we have a blood alcohol content for driving, theoretically you could have one for marijuana. Of course, that's going to be an invasive type of testing that you'd have to do. But that's a possibility. It may even be that your case-by-case situation is based on even down to the employee, which doesn't make systemization and procedure is very useful, but that may be how it has to go. No one knows yet. But I do think that in the event that time comes, a simple zero tolerance policy will probably not be sufficient to protect the employer. Good news is we don't have to worry about that yet. That's still a long time off. There is no indication really that the feds are going to legalize marijuana or create a medical use application. And so until that happens, even if South Carolina were to legalize or whatever, I just don't think that how you do business now will have to change all that much, if at all.
Any other questions from the group? I know one thing I want to address before we wrap up today, and this is something that a lot of our customers see here, which is we border North Carolina and Georgia very closely. Mm-hmm. We have a lot of our clients who operate, maybe their facilities operate in South Carolina, but they have their employees that live in the opposing states. Mm-hmm. Let's assume that one of our neighbors legalizes before we do.
Yeah.
How do we see that affecting policy? And I feel like we've answered this, but I just want to, that's something that the question comes up quite a bit is, I live in Georgia, it's legal to consume personally, it's legal medically. Let's just say it's legal medically, I have a prescription. I work in South Carolina, but it's not.
Yeah.
Where are our policies from?
I think, I don't think you change anything to accommodate that employee, not until federal law changes. I think the answer back to that employee would be, look, if you want to take advantage of the laws of that state, then you need to find an employer in that state. Our business is located here. We are subject to the laws of this state. We're not subject to the laws of North Carolina, Georgia, or wherever. We're subject to the laws of South Carolina. You're subject to the laws of South Carolina as long as you're on the property here. If you violate our policies, then we'll terminate. And as you guys know, whatever your policy is, make sure to enforce it, right? Just do it consistently, do it even-handedly, even if that means the employee comes from across a state line somewhere. If they're coming here, they're subject to what this state says and what your policy is.
Any more questions today? No? Steve, thank you so much.
Thank you, guys.
Yeah, thank you. Steve's going to be around. We're going to wrap up today, but Steve will be around for a little bit if anybody has questions. Like I said, we'll get this edited and set up on YouTube, so if you ever want to watch it again or share it with anybody else, please do. If you do have any questions for us afterwards, please stick around. We'll be good now to talk. So once again, have a wonderful Friday and a wonderful weekend. Thank you for being here.
Thank you all.